Hello students, welcome to the lecture on Indian Partnership Act. After this lecture, you will be able to learn the following objectives. Discuss the partnership, define the types of partners, discuss the registration of partnership firm, explain the rights of partners, describe the partnership property, explain the dissolution of firm. Introduction. Now let us know more about Indian Partnership Act. Prior to 1932 Act, 1872 contained the laws relating to partnership in India. As the provision therein were not exhaustive, it were considered expedient and necessary to separate and supplement the laws relating to partnership and to embody it in a separate enactment. Hence, the Indian Partnership Act 1932 came into existing. It came into force on 1st October 1932. This act is broadly based on the English Partnership Act 1890, which has been the basis of partnership laws in all countries which have adopted English common law, including the United States of America.
Today I am going to tell you something about the partnership. As we all know that partnership is a business, partnership is a firm, partnership is a type of business in which two or more persons are included or combined to do some work. So let us talk about the partnership. As we all know that in India there is a Indian Partnership Act which is launched in 1932, and after that there are so many amendments were made in the Partnership Act. Today we are talking about the partnership. Let's see the main features of partnership. As we all know that partnership means the people are collecting and doing some work with some objective. Let us see the features of partnership. The first one is at least two persons. As we all know that partnership cannot be with one person. So there must be at least two persons. There is limitations of partners as maximum number of partner in a general firm, in a general business there must be maximum number is limited till 20, and in banking business there is a the partners are limited till 10 maximum numbers. Third point is agreement. As some people are, if they are agreed to do some work, so there must be an agreement. Without agreement or without contract, they cannot start a business. As we all know, in the eye of law, the agreement may be implied or expressed. It may be implied. They can sit together and be on certain conditions. They can be justified on some conditions. So there must be an agreement. It may be expressed or implied. There is business. If we are talking about the partnership and concern of business, so there must be a business, a proper business which is held by all of the partners. Sharing of profit. If partners are doing work together without sharing of profit, it means this is not a partnership firm. If the partners are working together and sharing the profit, it means this is a partnership firm. Sharing of profit, it is not necessary that all partners are share profit equally. It may be according to their agreement or another, or there may be many stages of sharing of profit. Next is mutual agency. As we all know that partnership firm may be registered, may not be registered. So it is a mutual agency where all the partners work together for their mutual interest. Next is seal of transfer of interest. As we all know that in company it is easy to share the transfer the share to anyone, but in partnership firm it is not easy to share the to seal the transfer, as if the person is selling its interest or its share of the partnership firm, it means the partnership firm is dissolving. Next is partition and dissolution. A partner can ask for the dissolution of partnership firm but cannot ask for the partition of partnership firm. As if the partner is asking about the partition of partnership firm, it means the partnership firm is dissolving. Line on property. Next is, so line on property means if the partner is working on behalf of the partnership for the firm, and whatever work he has done till the limit of that work, he has line on property. So whenever the partnership firm is dissolving or having the wind up process, the partner can ask for the property up to the limit of his expenses. Unlimited liability, all the partners, as in we have learnt in company that partners, that the members of company has limited liability till their share, but in partnership form all the members has unlimited liability. Registration, as we have discussed earlier, that partners are, it is not necessary in a partnership firm that the registration is not compulsory. The partnership firm is may be registered, may not be registered.
Partnership. A partnership is a relation between two or more persons who have agreed to share the profits of business carried out by all of any of them acting for all. The persons who have entered into the partnership with one another are called individually partner and collectively firm, and the name under which the business is carried on is called firm name. Essential characteristic of partnership. Agreement. The relation between the partners is created by agreement. As per section 5, the relation of partnership arises from a contract and not from status. If the agreement between the partners is unwritten, it is called as partnership deed. It may be expressing, that is oral or written or implied. The agreement must be lawful. The partnership agreement should not necessarily be in writing. Number of persons. There must be at least 2 persons. All the persons must be competent to enter into a contract. Maximum number of persons. In case of banking business, the maximum number of partners is 10. In case of other business, the maximum number of partners is 20. Business. The partnership can be formed to carry on business and not for social welfare or charitable activity. The business includes every lawful trade, occupation and profession. Sharing or profit. There must be a sharing of profits. The requirements of sharing of profits does not require that all the partners must share the profits equally. It is possible for the partners to agree to share the profit in such a ratio as they may mutually agree. Mutual agency. There must be a mutual agency. The mutual agency means the principal-agent relation. It means any one partner can act for the others and bind them as well as to the firm by his act. True test of partnership. Whether an association of person is partnership or not shall depend upon various factors. No single factor can determine the existence of a partnership. A mutual agency is the fundamental test of partnership. Cases where no partnership exists. One of the essentials of partnership is the sharing of profits. However, mere sharing of the profits does not necessarily mean that the association is the partnership. In the following cases, there is the sharing of profit, but there is no partnership. The joint owners of a property sharing the profits or gross returns arising from the property do not become partners. Also, there is no mutual agency. The lender of a firm who receives a share in the profit. Types of partners. There are different types of partners. Actual or active partner. He is also known as the ostensible partner. He takes active part into the business of the firm. He is liable for all the acts of the firm. He must give a public notice of his retirement from the firm. Sleeping or dormant partner. He does not take part in the business but is liable for all the acts of the firm. He need not give public notice of his retirement from the firm because the public does not have any idea that he is a partner. Nominal partner. He lends his name to the firm. He does not take part in the business of the firm but is liable for all acts of the firm. He does not contribute any capital to the firm and does not share any profits from the firm. The purpose of admitting a partner as the nominal partner is to use the name of such person. He must give public notice of his retirement from the firm. Partner in profit. The partners may lawfully agree that one or more of them shall not be liable for the losses. In such a case, the partner who is entitled to share the profit but is not liable for the losses is called as the partner in profit. He is like any other normal active partner. Sub-partner. He is one who shares the profit of another partner. The sub-partner is not a partner in the original firm. He is not liable for the act of the firm. He does not require giving public notice. The sub-partner is excluded while counting the total number of partners of the firm. A sub-partner is a transferee. Share of profits. The sub-partnership firm also obtains the right to receive the specific share of profits from the main firm under a legal relationship to a trust. Therefore, it can also be specifically provided in the sub-partnership deed that the main partner holds a position of trust like a trustee holding a fiduciary capacity and role for the benefit of the sub-partnership firm in relation to the share and interest he acquires in the main firm. Partner by estoppels of holding out. Sometimes a person is not a partner in a firm, but he may be liable for the debts of the firm as if he were a partner. Such a partner is called a partner by estoppels or holding out. Minor partner. The minor may be admitted to the benefits of a partnership with the consent of all the partners. The liability of the minor partner is confined only to the extent of his share in the profits and the property of the firm. He cannot be declared insolvent, but if the firm is declared insolvent, his share in the firm vests in the official receiver or official assignee. There is no provision in Section 30 of the Partnership Act 1932 requiring an agreement either between the minor or between the natural guardian acting for and on behalf of a minor and other partners. Whosoever receives benefits on behalf of a minor is bound to render an account to the minor. Failure to do so will give a valid cause of action to the minor within 3 years of his attaining majority. The signature of either the minor or a person acting as guardian of minor is a neutral circumstance. It neither fastens any liability nor creates any rights which are not otherwise conferred by law. There is no requirement in law obligating the guardian of a minor to sign the partnership deed on behalf of the minor. Failure to do so would not vitiate registration of the firm. Registration of partnership firm. A registration of partnership firm is not compulsory, it is optional. Therefore, the registration of the firm can be effected at any time. Procedure for registration of firm. An application for registration is required to be made in the prescribed format to the registrar of firms with the prescribed fees and shall contain the following particulars: the firm name, the place or principal place of business of the firm, the names of any other places where the firm carries on business, the date when each partner joined the firm, the names in full and permanent addresses of the partners, and the duration of the firm, if any. Registration of alteration. The following changes are required to be registered with the registrar: alteration in the firm's name, alteration in the location of the principal place of business of a registered firm when a branch is closed or a new one is opened, changes in the names and address of the partners, changes in the constitution of registered firm due to the admission and retirement of the partners, dissolution of a firm should also be reported. Withdrawal or continuation by a minor on attaining the majority. Time for registration. The Act does not provide any time for the registration of the firm. It is possible at any time. The Act has not prescribed any penalty for the non-registration of the firm. No suit can be filed in any court by the firm against any third party unless the firm is registered. Effects of non-registration. If the firm is non-registered, following disabilities are created. An unregistered firm or its parties cannot file a suit against the other partners of the firm to enforce a right arising out of a contract. An unregistered firm or its partners cannot file a suit against the third parties. An unregistered firm or its partners cannot claim the set-off in a suit filed against the firm by a third party except for a sum not exceeding ₹100. The non-registration of the firm, however, does not affect the followings: the right of the third parties to sue the firm or its partners. The partner of the unregistered firm can file a suit for the three matters as under: for the dissolution of the firm, for the accounts of a dissolved firm, for the realization of the property of a dissolved firm, the power of an official assignee or receiver to realize the property of an insolvent partner, the rights of the firms or the partners of the firms having no place of business in India, right to set off where the claim does not exceed ₹100. Reconstitution of firm. The reconstitution of the firm means a change in the constitution of the firm. It means the old partnership ends up and a new partnership commences. Liability of an incoming partner. A new partner is not liable for any act of the firm done before his admission. However, an incoming partner may by an agreement agree to become liable for the acts done before his admission provided the newly constituted firm has agreed to pay the debts. The creditors have agreed to accept the new firm as their debtor and discharge the old firm from its liability. If a minor on attaining the majority elects to become the partner, he will be liable for all the acts of the firm done since he was admitted to the benefit of the partnership and not from the date he becomes a major. Retirement of partner. A partner may retire in accordance with the partnership deed or with the consent of all the other partners, or where the partnership is at will, by giving a notice in writing to all the other partners of his intention to retire. Liability of a retired partner. A retired partner is not liable for any act of the firm done after his retirement. However, he is liable for the act of the firm done before his retirement unless he is discharged. Rights of a retired partner. A retired partner may carry on a business competing with the firm and he may advertise such business, but he cannot use the firm's name, represent him as carrying on the business of the firm, solicit the old customer of the firm. When the retiring partner is not paid the amount due to him, final settlement money, he has the right to receive the higher of the following amount: the interest at the rate of 6% per annum on money unpaid, the proportion of the profit earned by the firm after his retirement. Expulsion of partner. The general rule suggests that the partner can't be expelled from the partnership. However, the partner may be expelled subjected to the following condition. The power of expulsion of a partner should be confirmed by the partnership deed. The power should be exercised by a majority of the partners. The power should be exercised in good faith. Tests of good faith for expulsion. The following are the three criteria for the test of good faith. The expulsion must be in the interest of the partnership. A proper notice is served to the expelled partner. He is giving on opportunity of being heard. If a partner is expelled without complying with the above conditions, the expulsion is called irregular. Insolvency of partner. He ceases to be partner on the date on which the order of insolvency is made. The firm is also dissolved on the date of the order except the agreement that provides the contrary. The estate of the insolvent partner is not liable for the acts of the firm done after the date of the order of insolvency. Debt of partner. The debt of any one partner results into the dissolution of the partnership. The firm is dissolved unless otherwise agreed in the partnership agreement. No requirement of the public notice. The estate of the deceased partner is not liable for act of firm after his death. Transfer of partner's interest. The transfer of interest may be made by way of absolute sale, creation or charge or otherwise. The transfer of interest may be absolute or in part. A partner can assign his share of the profit and his share in the assets of the firm to the outsider. In that case, the transferee does not entitle to participate into the business of the firm, to require the accounts of the firm, to inspect the books of the firm. But such a transferee is entitled to receive the share of the profit of the transferring partner. He is bound to accept the account of the profit agreed to by the partners. In the case of dissolution, to receive the transferring partner's share in the asset of the firm. Where a partner has transferred the whole of his interest in the firm to a third party, or where his share has been attached under a degree or sold in the recovery of the areas of the land revenue, the court may dissolve the firm at the instance of any other partner. Rights and duties of partner after reconstitution. The mutual rights and duties of the partners in the reconstituted firm remain the same as they were before the change. Rights of partners. A partner can have the following rights. Right to take part in business. In the absence of any agreement between the partners, every partner has a right to take part in the conduct of the business. Right to be consulted. The ordinary matters of the business may be decided by the majority, but no change can be made in the nature of the business without the consent of all the partners. Right to access the book of account. Every partner has a right to access and inspect and take copy of the books of the firm. The minor partner has a right to inspect and copy the accounts of the firm, but not the books. Right to share profit. All the partners are entitled to share the profit equally. The agreement between the partners may provide otherwise also. Right to interest. A partner is entitled to claim interest on the capital out of the profit if agreement provides so. The partner is entitled to claim interest on any loan or advances he has made to firm at the rate of 6% per annum. Right to be indemnified. Every partner has a right to be indemnified by the firm in respect of the payment and liability incurred by him in the ordinary course of business. Right to the use the firm's property. Every partner has a right to use partnership property for the purpose of the business of the firm. However, a partner may use the partnership property for his personal purpose if the agreement provides so. Right to retire from partnership. Every partner has a right to retire from the partnership either by giving a notice in writing to the other partners or as per the method agreed under the partnership agreement. The retired partner has a right to carry on the competition business and also has the right to advertise his new business. Right to receive remuneration. No partner is entitled to receive any salary or remuneration for taking part into conduct of business. However, agreement between partners may expressly provide for payment to remuneration to working partners. Right not to be expelled from partnership. Every partner is entitled to continue as a partner until death or retirement. No partner shall be expelled. Duties of partners. Every partner has the following duties. Duty to share losses equally. Every partner is liable to contribute equally to the losses of the firm. However, an agreement between the partners may provide otherwise. Duty not to act for individual benefit. All the partners are duty bound to carry on the firm's business to the greatest common advantage and not for the individual benefit. Duty not to carry on any other business. If any personal profit is made by any partner from the partnership transaction or from any use of the partnership property, name or business connection, he must account for it and pay it to the firm. In the absence of any agreement, a partner cannot carry on the competing business. If he does, he is bound to account for and pay to the firm all the profits made by him in that business. Duty to indemnify the firm from loss caused due to willful neglect. The partner has to indemnity compensate the firm for any loss caused to the firm by his willful neglect. However, this duty may be excluded by an agreement between the partners. Duty to make proper use of property of firm. The partner must use the firm's property for the purpose of the business of the firm. No partner should use the partnership's property for his personal benefit, otherwise he is liable for the profit he has made by using the property. Partners' compulsory duties. They are also known as mandatory duties. The mandatory duties are as follows. Duties of good faith. This is the primary and the most important duty of every partner. Every partner is duty bound to act in good faith. It means to remain faithful to one another. Duty to carry on business to the greatest common advantage. Every partner must conduct the business of the firm in such a manner which is most beneficial to the firm. No partner should make any personal profit at the expenses of firm. Duty to render true accounts of firm. Every partner should keep proper accounts of all the money transaction relating to the business of the firm. Every partner should explain all the accounts to the other partners. Duty to give full information. No partner should hide or conceal any material facts and information affecting the business of the firm from any other partner. Duty to indemnify for loss caused by fraud. If any fraud is committed by any partner in the conduct of the business of the firm, he shall be liable to indemnify the firm from loss caused to it. Duty to act within authority. Every partner is duty bound to act within the scope of his authority expressed and implied. Where he exceeds the authority confirmed on him and the firm suffers a loss, he shall have to compensate the firm such loss. Duty to be liable jointly and severally. Every partner is liable jointly and severally for the acts of the firm while he was partner. Partners' optional duties. They are also known as the general duties of the partner. Unless otherwise agreed by the partner, every partner has the following duties. Duty to share losses equally. Every partner is liable to contribute equally to the losses of the firm. However, an agreement between the partners may provide otherwise. Duty not to act for individual benefit. All the partners are duty bound to carry on the firm's business to the greatest common advantage and not for their individual benefit. Duty not to carry on any other business. If any personal profit is made by any partner from the partnership transaction or from any use of the partnership property, name or business connection, he must account for it and pay it to the firm. In the absence of any agreement, a partner cannot carry on the competing business. If he does, he is bound to account for and pay to the firm all the profits made by him in that business. Duty to indemnify the firm from loss caused due to willful neglect. Partner has to indemnify, compensate the firm for any loss caused to the firm by his willful neglect. However, this duty may be excluded by an agreement between the partners. Duty to make proper use of property of firm. No partner should use a partnership property for his personal benefit, otherwise he is liable for the profit he has made by using the property. However, this duty may be excluded by an agreement between the partners. Partnership property. A property originally brought in the common stock of the firm by the partner while at the time of joining the firm is the property of the firm. A partner may contribute personal property to the partnership, but the contributed property becomes partnership property unless some other arrangement has been negotiated. Similarly, if the partnership purchases property with partnership assessed, such property is presumed to be partnership property and is held in the partnership's name. Capital of partnership. Capital of a partnership refers to the aggregate of the sums contributed by its member for the purpose of commencing or carrying on the partnership business and intended to be risked by them in that business. The capital of a partnership is a sum fixed by the agreement of the partners as the actual asset of the firm vary from day to day and includes everything belonging to the firm and having any money value. The capital of each partner is not necessarily the only item to be considered in ascertaining the amount due to him from the firm. Where the property used by partnership is partnership property, it is not necessary that every partnership for the purpose of its business should own and utilize its own partnership property only. It can also utilize a property owned by others for the purpose of its business. Such a property would become partnership property only if there is an agreement expressed or implied that the property under the agreement of partnership to be treated as the partnership property. In the absence of any agreement between the partners, the property shall be deemed to be partnership property in the following cases: whether it is originally brought into the common stock of the firm, whether it is acquired by purchase or otherwise or for the firm, whether it is acquired for the purpose and in the course of the business of the firm. Essentials of property of the firm. The property belonging to a person in the absence of an agreement to the contrary does not become the property of the partnership merely because it is used for the business of the partnership. It would become property of the partnership only if there is an agreement, expressed or implied, that the property under the agreement of partnership to be treated as the property of the partnership. Presumption about partnership property. It may be noted that a partner is a trustee of the partnership property standing in his name, and no partner can be said to have any beneficial interest in any particular estate or property until the partnership is dissolved. Rules in coming for the conclusion whether property is partnership property. The following rules may be taken as guiding factors in determining whether a particular property is partnership property or not. All property, rights and interests which the partners have thrown into the common stock at the beginning of the business or subsequently contributed by them or acquired by means of common funds are to be regarded as property of the firm. Property purchased with money belonging to the firm is deemed to be the property of the firm. The mere fact that a particular property is used for the purpose of the firm does not necessarily make it a partnership property. Partnership interest. Partnership interest means a partner's share of the profits and losses of a limited partnership and the right to receive distribution of partnership assets. Authority of partner. The authority of the partner may be expressed or implied. Any act of the partner done within his express authority or implied authority shall be the act of the firm, and consequently the firm shall be bound by it. Express authority. An express authority is given to a partner by an agreement, implied authority. This is an authority which is not given to a partner by an agreement but by law. The act of the partner will be within the implied authority of the partner if the following conditions are satisfied. The act must be done in the ordinary course of business. The act must be done in the usual way. What is a usual way? It is a question of facts and circumstances. Acts within the implied authority of partner. It includes to purchase and sell the goods on behalf of the firm in which the firm deals, to receive payments from the debtors of the firm and give receipts for same, to settle accounts with the person dealing with the firm, to engage as servants for the partnership business, to borrow money on the credit of the firm, to draw, accept, endorse negotiable instruments in the name of the firm, pledge any goods of the firm for the purpose of borrowing money, to employ a lawyer to defend an action against the firm. Acts outside the implied authority of partner. It includes to submit a dispute relating to the business of the firm to arbitration, to open a bank account on behalf of the firm in his own name, to compromise any claim or any portion of a claim by the firm, to withdraw a suit or proceeding filed on behalf of the firm, to admit any liability in a suit or proceeding against the firm, to acquire immovable property on behalf of the firm, to transfer immovable property belonging to the firm, to enter into partnership on behalf of the firm. Limited partnership. A limited partnership is similar in many respects to a general partnership, with one essential difference. Unlike a general partnership, a limited partnership has one or more partners who cannot participate in the management and control of the partnership's business. A partner who has such limited participation is considered a limited partner and does not generally incur personal liability for the partnership's obligation. A limited partnership must have one or more general partners who manage the business and who are personally liable for partnership debts. Dissolution of firm. On the dissolution of a firm, every partner is entitled to have the property of the firm applied in the payment of the outside debts and the liabilities of the firm, and have the surplus distributed among the partners in accordance with their rights. However, no refund can be claimed where the dissolution is due to the debt of a partner, is due to the misconduct of the partner who had paid the premium, is in pursuance of an agreement which contains no provisions for the refund of the premium or any part thereof. Liabilities of partners on dissolution. After the dissolution of a firm, the authority of each partner to bind the firm and the other mutual rights and obligation of the partners continue, so far as may be necessary for the following purposes: to wind up the firm, to complete the transaction begun but unfinished at the time of the dissolution. Now in the end, let us summarize what we have learned in this lecture. Summary. The person who have entered into the partnership with one another are called individually partner and collectively firm, and the name under which their business is carried on is called firm name. The partnership can be formed to carry on business and not for social welfare or charitable activity. The business includes every lawful trade, occupation and profession. The servant or employee engaged in a business receives his remuneration as a share of the profit. The mere fact that an employee gets a share of profit does not make him a partner. A registration of partnership firm is not compulsory, it is optional. An unregistered firm or its partners cannot file a suit against the other partners or the firm to enforce a right arising out of a contract. A person, if competent to enter into a contract, can be a partner in the firm. One person can be a partner in any number of firms. The debt of any one partner results into the dissolution of the partnership. On the dissolution of a firm, every partner is entitled to have the property of the firm applied in the payment of the outside debts and the liabilities of the firm.